In this module, we're looking at merits review. Last week, of course, we looked at judicial review. And judicial review has a lot of precedents and a lot of law that sits in behind the origin of judicial review. Merits review is comparatively recent, and you'll find there's an case law attached to this because it's not a legal process, it's an administrative process. So the readings this week are fairly straightforward. They're quite lengthy again because we try to cover as much detail as possible so that you get the entire scope of the situation, but there's nothing very terribly tricky or legally complex here. The reading from the textbook this week provides you a very good introduction and overview of the field and of the concerns that are raised over time. Because, as you'll probably see by now, what we've basically established is two different remedy pathways for people. One is a legal pathway, the one we covered last week, and the other is a procedural one, a bureaucratic one. Although to the layperson and the casual observer, these things don't really look all that different. The AAT or the state bodies do sit in a tribunal format. They look like a court. People give evidence. They're not bound, there's no rules of evidence, although they tend to follow something that looks like a legal procedure along the way. So it can be very confusing to onlookers, and I know every week I say separation of powers, and you're probably well and truly sick of that, and I hope that's because you're well and truly on top of the issue. But it is something that does become very, very important here. Because unlike judicial review, which is very much bound up with the legal framework of what it can and can't do, the sky's the limit with merits review. The tribunal can make any decision they like. They stand in the place of the original decision maker, so it's unlike judicial review where you're basically criticising the decision itself and then remitting it back to be made again if there are problems with it, which can be very frustrating if they just make the same decision again but do it in the right way. With merits review, you can actually replace the new decision of the body with it replaces the original decision. And it can also do things like consider new evidence. They can consider things that the original decision maker didn't hear. Something which is, inimical to legal process. It's something that wouldn't happen in a trial, for instance. It would be very, very difficult to introduce new evidence that wasn't heard at a trial. And sometimes you can do it, but it's not something you can easily do. In merits review, anything goes. And it can be very frustrating for lawyers to appear before something like the AAT because quite often they play fast and loose with a lot of the rules as well. That it's something that makes lawyers fairly uncomfortable. A classic example is time limits. A rental bond, for instance. There's a time limit for which a landlord can apply to access the bond. Otherwise, under the legislation, it returns to the tenant. One of the problems with the rental bond authority division of the AAT is they don't care about timelines. They don't care about deadlines. If the landlord has waited outside the period and still hasn't returned the bond, there's not an automatic right for the tenant to get it back then, even though the law seems to say that. So lawyers get a little frustrated by these processes and by the fact that the tribunals have this sort of wide open power to make new decisions. And on the flip side, the tribunals often get a bit frustrated by lawyers. And I've referred you in one of the earlier readings to some of the critiques of the early AAT, where initially they were set up, they prohibited lawyers from being members, they prohibited lawyers from attending or representing people, and it was a very, very anti-legal process. But over time, there was more and more legal process introduced, and part of it was really because the rules around judicial review are good rules, and they're a very solid way of thinking about decision-making and decision-making processes. So why not look at rules such as natural justice? Why not look at the right to be heard? Because that's a fundamentally good way to approach it. But there has also been a growth in legally qualified people or legally trained people who are members of the AAT. And depending on where you sit on the continuum of this is either a good thing because we're bringing the AAT more into line with the expectations of the legal community, Or for some members of the AAT, this was considered to be the end of the world, and their beautiful dream of a non-legal process where lawyers were kept out was compromised by these lawyers who came in and suddenly brought in their legal ways of thinking. There's a critique referred to a few weeks ago of William de Maria's work, and he was a social worker, and he was a member of the AAT, and he was very, very opposed to the legalisation of the AAT because he thought as a social worker his discipline had a much better way of solving the sorts of problems that the AAT faced than lawyers. So think about that. There are more than one perspective. There's more than one perspective on this, and certainly as a lawyer and someone who's going down that pathway and thinking as a lawyer, it can seem very frustrating and inconsistent that this tribunal has a lot of power. They don't seem to be bound by legal rules, and they seem to be able to work without precedent. But to non-legal people, this can also be liberating. It can be a way of approaching problems in a way that's not limited by solving a problem the same way you've done in the past. I mean, that's what precedent is. It's to solve a problem using exactly the same methods and approaches as you've done previously. And that obviously has a benefit when it comes to consistency. And that's one of the fundamental merits of the, I shouldn't have used the word merit when talking about merits review. It's one of the benefits of the common law method is that it provides consistency over time. You're more able to guess what's going to happen in the future. However, that might be at the cost of justice in a particular case. And a tribunal like the AAT has the ability to make an independent decision every time. And those decisions may be inconsistent over time, but at least they focus on the particular justice of the particular individuals in that case. And that's also, I mean, one of the other critiques that's referred to in your readings, in your study guide this week, is that organisations do tend to find that the AAT focuses on the individuals a little more than the organisations. And judicial review, there tends to be more of a broad picture of organisation and decision making. The AAT tends to be about the individuals, particularly the people bringing an action before the AAT. And again, it depends on your perspective if that's a good thing or a bad thing. But in certain divisions of the tribunals, and I know from experience, colleagues have spoken about VCAT, Victorian Civil Administrative Tribunal, there is certainly a sense that repeat players in the system feel they know how to play the tribunal. They know how to game the tribunal because they don't have a system of precedent, because they don't keep records, because they don't have that kind of rigour of decision making that a court would have. For instance, property developers will say it's easy. If you want something, you always ask for more than what you want, and what VCAT, what the tribunals always do, is just try and find a median in the middle. So if you want to put a 20-storey high-rise in next to someone's house and they're going to object, you ask for a 40-storey high-rise, knowing that they will cut it back to 20 as a compromise. So there is also that sense that it's a system, because of its lack of rigour, that can be gamed, and it can be gamed more effectively by repeat players in the system. So the property developer who's before VCAT, or whatever the state tribunal is, from week to week, knows the strategies, they know the game. They're better at playing it. Whereas the person who is objecting to the high-rise going in there next to their backyard, this is the first time they've ever appeared there. They don't know the system, they don't know how to play, and they don't really have the ability to say, well, we want 0 stories, but we'll accept 10. They don't want the high-rise there at all. So where there's a certain appeal for the tribunal to be able to say, we've mediated, not that there's a mediation process, but we've acted as an intermediary, and someone wants this, someone wants that, and we've met them halfway. Sometimes some issues really don't need to be met halfway. Sometimes it's an all or nothing issue. So certainly there is that critique of those tribunals from that perspective of the repeat player and the single player, and the planning permissions and the planning divisions are the ones that seem to cop that the most. The other, I guess, is probably the rental bond authorities. They tend to be criticised fairly heavily as well. So anyway, getting back to it, read the materials for this week. Make sure you've got an overview of what's going on. And remember, the difference between this and judicial review, even though they look similar, is that they're completely different animals. Judicial review, legal process, comes under the judicial head of power, and it's the oversight of the administrative limb of body to make sure that they're actually obeying the law in the way in which they operate. Administrative review through a tribunal, the merits review, on the other hand, is of administrative character. There's nothing legal about it at all. Although they might, you know, they operate under law, under legislation that governs them, and there are rules that they follow. But the character of what actually happens there is administrative. It's the same way where you might have an appeal to someone's supervisor. So someone makes a decision, and if you don't like the decision, you can appeal to their supervisor within 30 days. It's that kind of process rather than an external legal process. And in fact, what the clever thing that the AAT did when it's in its initial format was take all these labyrinthine, diverse and different pathways and different appeal bodies and different appeal mechanisms that existed, and created one meta appeal body. So people didn't have to be able to say, well, if I've got to appeal to this person and I've got to fill out a form 74/A and go to this person, but if I don't fill out this form and move to this person first, you know the kind of deal that the bureaucracies are notorious for. It created a one-stop shop. It created one environment where people could go and say, I've got a problem and I need to have it resolved. Okay, so hopefully that's making more sense. Next week we get more into the depth. We go back to judicial review. We don't spend a lot of time on merits review because there's not a lot to say. We've got to see what the overview is, but basically anything goes there, and it's really about being able to make a persuasive argument rather than argue the law. But over the next few weeks we're going back to the law. So we're looking at judicial review, we're looking at the rules and guidelines that govern judicial review. The bonus is, if you actually go to the merits review tribunals, is the same kind of arguments can often be used. So if you're going for judicial review and you're arguing for natural justice, you've got to make sure you follow the precedents. You've got to make sure you're using the precedents on natural justice. If you're going to a tribunal, you can make the same kind of arguments, but you're not relying on precedents. You're just relying on, I guess, common sense. And that's, I think, what makes or breaks merits review, is what is common sense? Is it something that's something we can test people for? And do people who make common sense decisions necessarily see the whole picture? I mean, there is a reason why precedent exists. There's a reason why lawyers exist. And people like to slag off lawyers a lot and see that they complicate issues and everything else. But sometimes when you see the sorts of challenges people have within the merits review system, you can see that there's a very good reason why lawyers exist. But maybe that's just because I'm a lawyer. Maybe that's just my own personal bias. So you'll have to think about that one for yourself and see what you think.